Susan, did you have a story to tell or a question to ask?
Hi, thanks for taking my call. I had a question to ask, or maybe some questions. I just need to find out what your perspective is on an effective strategy to kind of circumvent the evidence code, in my favor. In my case, I'm from California. I've got a minors attorneys council, county council, and also it does seem like the judge is really making sure that any applicable evidence in my defense will not be submitted. Will just not, they're finding any kind of ruling to make sure I'm not effective in defending myself.
Secret, How to Fight CPS and Win, and I'm joined today by my co-host, Brian Hamilton. Brian, what did you think of that last call?
It's honestly a very common thing that I see with my own clients in therapy is that they are, their kids are placed in foster families where there is potentially abuse or neglect that is occurring, and a lot of them feel very powerless to be able to do much of anything about it. And one of the things that I often try to recommend to them is very much what you do is just like talk with your lawyer, see if there's anything you can do about that. But I also try to recommend that they even reach out to things like the CASA programs. These are individuals that basically do advocacy work for children. CASA stands for Court Appointed Special Advocates. And obviously not all of them are the greatest programs, but a lot of times you can get somebody who can get in there, take a look and advocate for your kid, and even, identify something that maybe CPS is not recognizing in terms of that abuse, because a lot of times CPS will overlook it because of the fact that it is so difficult to find families who are willing to foster children.
Mm-hmm. All right, let's take another call right now. Let's talk to Susan from California. Susan, did you have a story to tell or a question to ask?
Hi, thanks for taking my call. I had a question to ask, or maybe some questions. I just need to find out what your perspective is on an effective strategy to kind of circumvent the evidence code, in my favor. In my case, I'm from California. I've got a minors attorneys council, county council, and also it does seem like the judge is really making sure that any applicable evidence in my defense will not be submitted. Will just not, they're finding any kind of ruling to make sure I'm not effective in defending myself. And it's just really disheartening. And they're finding any kind of, and they're deciding this before my jurisdiction trial. It's kind of happening kind of on the side. So before I even have the opportunity to defend myself, they're kind of saying no. We're kind of saying no, you can't submit this as evidence. And to be a little more specific to help so that I can get an answer from you is, like 800 pages, more than in excess of 800 pages, which demonstrate that, over the years, there have never been any allegations of abuse, like none, zero. Child is brought in timely for, annual care, is brought in multiple times during the year for ear infections. And, each time, you never know when a provider is going to say, okay, lift up that shirt or go put on a gown. And you don't always get the same provider. Because you might be urgent care in the evening at one location. And so just over the years, it's just basically an audit over the years, and not one allegation. So I just need to know, how do I...
Susan, hold on a second. Are you a client of my office?
No, I'm not.
Okay, because I had a long discussion about a case with an attorney from my office from your county. I didn't mention your county. I just said you were in California, but on the call board, I see where you're from. And this person has the exact same problem, trying to get evidence in, and they're being blocked in every way. And one of the things that I told my attorney was, sometimes you're going to have to take appellate remedies either before or after the jurisdictional and dispositional hearing. Sometimes, in that particular case, I think I was told that there were motions made and hearings and to argue whether evidence was going to be let in and let not. In this particular case, apparently the judge ruled that certain evidence that would help the mother would not be admissible. So the only thing that you can do is seek appellate remedy by way of what's called a writ or by way of an appeal after the court makes a decision. Now, in this particular case, I would bet, a quarter that the position taken by the mother was the more accurate position about letting into what I consider exculpatory evidence of what they call custom and habit. But the judge ruled the other way, which, that happens. Judges make decisions for whatever reason, and sometimes they're right, sometimes they may not be right. But when they're not right, what you have to do is you have to take an appeal or a writ to challenge the judge's decision either before or after the trial, which comes up. So it's interesting that you asked me that question. I just had a conference with one of my attorneys about this very issue in your county.
Yeah, I felt compelled to call in after seeing Brian's show yesterday, and the young lady who was speaking about, as a child, kind of the behaviorisms as a child that she, had to suffer through. And it's sort of the same thing that my child is saying that never happened. So it scares me, and, I have to do everything to fight for myself. And some of the things that she said yesterday, speaker, that I felt so compelled to call because I need this help, is that, things are being hidden with a sweater. And while that can be true for some, that was not true in my case. And so evidence like this is so critical. So I just wanted to find out what your, what you would do strategically to circumvent this. And so I have the answers. I appreciate that, which is, you said, filing for a writ.
Yeah. But the other thing is, I would talk to my attorney to talk about the potential of winning or prevailing on a writ or an appeal, which is always, a very small percentage. But sometimes you have to do that to preserve the record and to show the court that, you won't just sit back and do anything. And, when you believe the court has made a decision that's not correct. Okay.
Okay. Thank you for your time. I really appreciate it.
You know what? Thank you for calling and thank you for listening, Susan. Why don't you call back in 2 or 3 weeks? Let us know what happened on that jurisdictional and dispositional hearing, okay? All right. Mr. Hamilton, what did you think about that?
Well, it was interesting what she was saying about how it is, how people will hide those kinds of injuries that kids are having, with heavy clothes and things like that. And a lot of times it is difficult to see it. But one of the things that I also remember that guest mentioned on the show the other day was that there are also ways that you can tell, because what happened with her was that her pastor had basically reached down to touch her shoulder, and she flinched and jumped back. And so if you see that kids are engaging in that kind of behavior, if you see that they're suddenly more withdrawn than they have been in the past, if you see that they are out a lot of times from school, that those are some telltale signs that you can start to look for. Really, behavior is a big thing. If you start to see that they're exhibiting inappropriate behavior in the classroom of any kind, A lot of times that's indicative that something's happening at home that's upsetting and frustrating to them. And so it doesn't mean that they're a bad kid. It means that they are having a difficult time with what's happening at home. And so take a look for those things and try to be that adult who can be there for them the way that this my guest pastor was there for her. So
okay, very good. All right, we're moving into our second break. We're going to take a break right now. This is The Secret: How to Fight Child Protective Services and Win, and we'll be right back after these messages.